Okay, if you're planning to buy a home in Cedar Park, Leander, Georgetown, Round Rock, or anywhere else here in the Austin metro, there's a major legal change that is going to affect how you're going to see or tour homes. And it's how real estate agents that are licensed with the Texas Real Estate Commission are going to be, how we're allowed to work with you, because that's changed as of January 1st. So if you were not seen homes, or you've not toured any homes yet this year for the spring and summer selling season, and you're asked to sign something this next time, don't get nervous. They're just following the law, and they're following the requirements and the notices that are required under the law. So let's dive into this a little bit deeper. So when you go out there as a buyer and seller touring homes, you are comfortable and confident with what you are dealing with and the things that you're going to be asked to do. So as of January 1st, 2026, the Texas Real Estate License Act, and I might refer to as TRELA, went through the Senate Bill 1968 last year, and it fundamentally changed how agency relationships are formed in real estate here in Texas. So what that means is agency relationships literally means the relationship between a client and a brokerage. That's the agency that is being created. So when I say agency, think brokerage services and the client that's hired that brokerage for services. That some of the language in the law has changed. And again, let's go a little bit deeper into this. So in plain English, being as plain as I can be, implied buyer agency is gone. So let's kind of like walk through what that means, because this is one of the biggest consumer changes faced in Texas. And we've dealt with it for years, all right? I'm sure anybody watching this video, most likely at some point, entered an implied agency agreement with a real estate agent they were working with. They didn't know it, but you did. So a quick history about how buyer agency used to work in Texas. So to understand what's changed, you need to understand how things used to work, all right? So back in the early days of real estate brokerages, long before online home searches like Zillow and even MLS systems, real estate agents typically worked only for the seller. That's it. All right. And the listing broker represented the seller. Other agents helped bringing the buyers, but in essence, the only agency, the only brokerage services that were being transacted was between the seller and the agents. So throughout MLS cooperation, which started as a little printed book that passed between brokerages, buy-side agents would show homes listed by another brokerage, but still technically worked in cooperation with the listing agent. So that gave rise to sub-agency. So basically, the agency with the listing broker and the buyer agent was a sub-agent to that relationship. And so sub-agency meant that the buyer's agent helped the buyer, but yet legally worked for the seller. Confusing, right? So you can imagine how much this confusion that's created over time. Like, who's working for who? Like, who's responsible for what, and who has my best interest involved, and who's working for me as a consumer. So over time, Texas law evolved to allow buyer representation. So if you were a buyer in Texas, right, prior to January 1st, 2026, for most agents, myself included, I always had a buyer's representation written agreement with my clients that clearly stated that I am working 100% for them, representing their interests, representing and providing the fiduciary responsibility and all the advice that I feel is required, and it is required under the law, to guide my buyer client to a successful transaction where they're happy with the sale of that property and they're happy with the home. So now an agent could formally represent the buyer with a signed agreement, and fiduciary duties are like loyalty. We learn this in real estate school. Confidentiality, advice on pricing, negotiation strategies, market interpretation, risk analysis. But this is, so through this, it got a little murky, right? Because I just went over that there was a signed written agreement that allowed me to do all of this on behalf of my client. So I was working exclusively for the buyer. I wasn't working for with the seller like we had done in the past, right? Through sub-agency, right? So this is where things get a little murky with regards to, and this is why the Texas law was changed, to give clarity. Along the way, there was a thing called implied agency. So if you ever heard the term, the walk like a duck and it quacks like a duck, then it's a duck, right? So what could happen with implied agency, right, is that even though the buyer never signed any documentation hiring the brokerage, agency could still be created through words, right? Advice, actions, conduct. And for example, if an agent said, this house seems overpriced, and suggested a sales price, discussed seller motivation, interpreted the inspection, talked about negotiation strategy, they may have created implied agency. Basically, I'm working for the buyer, but I have no written agreement formalizing the agreement. So I'm basically working on a handshake. That's basically implied agency. It's a handshake agreement. So even if nothing was signed, courts and regulators, legislators, people that work in the government, could determine that if an agent created an agency relationship based on how they behaved, meaning fiduciary duties could exist without paperwork, right? So that's what I mean by prior to January 1st of 2026, you as a buyer watching this video in Texas could have gone through a full transaction, worked with a sales agent, written a contract, gone through the transaction, closed the whole process, and never signed a buyer representation agreement, formally hiring that agent, because they did all of the work through implied agency that said that they were working for you. Even though that there was nothing in writing to say that they were, all of their actions stated otherwise. So the court would say, well, walks like a duck, quacks like a duck, it must be a duck. Hence, implied agency. So this is where things started to break down for consumers, right? So you have to understand that Texas Real Estate Commission and the legislators and the Texas laws, they're there to protect the consumers, not protect real estate agents. It gives us the lanes of how we're supposed to interact with consumers. So consumers would often didn't understand who was representing them, or if they were getting any representation at all, assumed the agent showing the home was their agent, right? That's happened, right? Well, they show me the house, obviously they're my agent. Like, who are they? They received advice without formal representation. I know this happens. They didn't realize loyalty obligations hadn't been created. This confusion became more pronounced as online. I'm sure y'all experience this. You go to homes.com, you go to realtor.com, you go to zillow.com, anyplace.com, and you press a button that says contact agent. You don't know who might be calling you. It could be the listing agent. It could be a myriad of different agents. It could be a staff working at that .com, whatever you called, or enlisted some help with a click of a button online. You don't know who you're talking to, right? You're just talking to somebody, maybe through text, maybe through chat, maybe through email. And this is how, real estate worked, right? Is trying to get people connected, to buy and sell homes. Makes sense. And then, we also have, open houses, and those became another buyer entry point, right? So agent met consumers before brokerage agreements were defined. So during the 89th legislative session, lawmakers passed Senate Bill 1968, all right, which modernizes what I mentioned earlier, TRELA. So that's, remember, the Texas Real Estate Licensing Act, right? And effective January 1st, 2026, so this is already in the rearview mirror, the biggest change is that subagency is eliminated. So remember what I mentioned earlier, right? That I would, the buyer agent would be working really for the seller, or they'd be working for the listing broker, that there was no fiduciary to the buyer in any way, shape, or form. So the subagency has now been eliminated. So we don't have that in Texas anymore. And the law now says that since it eliminates for all subagency in all real estate transactions, and basically this is for all residential transactions, commercial transactions, farm and ranch, vacant land. So it doesn't matter what, all of it, doesn't matter what the transaction is, subagency is dead in Texas. So that alone removes the old MLS cooperative agency model from modern practice. So what does that mean? Is that the cooperative nature of the MLS that provided a playing field of knowing the cooperative broker fee that was being paid for bringing a buyer is dead, right? That's gone now. So then the number 2 change that's happened with TRELA is that a written agreement is now required when we interact with the public. So it could be as simple as an open house. There could be a form required. There could be a form required showing a house, right? And there's a variety of different forms that could be signed. The simplest form that's out there right now is basically, it's a showing form. It says that I, as the agent that's showing this property, we're not working together. It has to be formalized in writing that we're not working together. And opening that door, I can give you 0 information. You ask me the square footage, I can give it. You ask me the offer price, I can give it. It's pretty much it. It's literally opening a door. If I can't go into any advice, I can't talk about the houses down the street, I can't talk about recent closings, I can talk about anything that would ever breach or go over that bridge of fiduciary or any kind of implied agency. Can't happen. I could lose my license, and I don't want to lose my license over just a simple conversation, right? So this is what it has changed. So there has to be a written agreement prior to showing a residential real estate property. So it could be that you already hired a real estate agent and you're just setting up your showings, right? That's, you already have a written agreement that you're hired a buyer agent, and however they're going to work with you, the fees that are going to be paid, that's in that agreement. And then there's another agreement that you could be signing that basically states, I don't work for you, I don't work for the seller, I don't work for anybody, I'm literally opening this door, and I cannot provide you any advice at all whatsoever, not on this property, not on that property, not one down the street, not the one next door, 0. All right? And you have to sign that form before you see the property, right? The only time that you have a caveat for that is, and this is probably the best route, if you really just want to see a property and you're a consumer, is call the listing agent, call the number, call the listing agent off the sign and ask to see the property. The listing agent does not require any kind of documentation for you to sign to see the property, because who is the listing agent representing? The seller. And it's the duty of the listing agent, in my opinion, to get the house sold. And that means showing it to people, right? So all this is meaning is before touring a home with a licensed agent, and in Texas you have to be a licensed agent in order to open a door, you must now sign one of the following: a buyer representation agreement that says I am representing you. It could be just for this property, it could be just for the day, or a showing only agreement. And that means that I, my brokerage, we don't represent you. There is no longer a legally safe middle ground. Doesn't exist. So for, you know, the curious sellers, you know, those curious neighbors that just want to go see what that neighbor looks like down the road because it just went on the market, and they want to compare notes because they might be thinking to get their house on the market. So let's go see what the competition is. I'll just call my friend to go open some doors. Not happening anymore, guys. And if you are experiencing in the market where you have agents that are opening the doors and not asking you to sign anything one way or the other, you are working with an agent that has zero idea what's going on in the market, has zero idea what's going on with the law, and you're interacting with them. Sorry, it's calling people out, but you need to know this as a consumer, and you need to be educated on what you are going to experience in the market. And when you do have an agent that's asking you to sign something, that should be like, this is an agent that knows what they're doing. This is an agent I can trust because they know what's going on, and they've been educated, and they're even educating the consumers on what is happening real time in Texas, right? So, like I said, there is no more middle ground. The end of implied agency is dead. It doesn't exist. So, as I previously said, you could meet an agent in Georgetown, Round Rock, Liberty Hill, Leander, Cedar Park, pick your poison, right? And then begin asking a lot of different things as a consumer. What would you offer? Why hasn't it sold yet? Do you think they'll negotiate? Without realizing, you're asking that agent brokerage level advice. And then that agency relationship is created through advice. So we can't even create, no advice, right? On these showings that you haven't hired me. So no more free information, basically, how I'm seeing it. So what does this mean now? Agents may only show property without representation if you've agreed that they're not going to represent you. And you know how you agree that they not represent you? Is you sign an agreement saying they've not represented you, right? And that they're not acting as your agent, and they're not providing advice, and they are not performing any brokerage activity. We are still required to provide the information about brokerage services, regardless of of what we're doing, whether it's a buyer representation or just a showing. The information about brokerage services is required by law. So again, that's another form you're going to see when you're interacting with a quality real estate agent that knows what's going on in the market and knows what's going on with the law changes. So they may confirm. I'm going to confirm, once we have an agreement and once we've signed, more information other than size and price, right? Because I'm not going to advise you on anything else during that showing that you haven't hired me on, right? Advice equals broker activity. Broker activity equals agency. And agency now requires something in writing first. So like I said, the showing only form that you're going to probably be seeing in the marketplace as a consumer, it's just another tool for the consumers to understand what's going on when they're doing that showing, right? And if you just want to access a home without representation, the law allows, right, the showing only agreement. I'm kind of going over this over and over again. So these showing only agreements, they're not exclusive. So you could sign with me. You can sign one with ABC brokerage down the road. You could sign 5 of those a day. There's no showing agreements. They're not exclusive. So you can sign as many as you want, You know, if you're coming in from out of town and you called 15 different agents to do 15 different showings, I would advise you never to do that. But if that's how you want to fly your flag, so be it. Each one of those 15 agents would need to have an agreement signed by you saying that they don't represent you. All of these forms by law can't exceed 14 days. They have to automatically expire. But then it has to clearly state that the agent doesn't represent you. A brokerage could create this form. Texas Realtors has a form that you might see more often. But in the end, these changes protect the consumer from confusion and the agent from accidental fiduciary duties. And I think overall, this is going to be a great change for here in Texas, specifically for buyer agency, meaning that consumers know which lane you fall in, meaning, am I being represented and do I have fiduciary responsibilities? Have I hired somebody to do work on my behalf? Or am I just wanting somebody to open the door? And the services are quite different between the two. Brokerage activity and brokerage services will allow you to understand what's going on in the market and how to position yourself to negotiate the best deal so you can get the house that you want at the price that you want. Just opening a door, there is no brokerage activity. You're not going to glean anything from me, or I hope from no real estate agent out there, on anything other than the size and the sales price that the agent is listing. And that's it. All right. So this is all about clarity. This is not sales pressure. It's compliance with Texas law, and agents must follow it now. So like I said, when you are getting out in the marketplace as a seller, as a buyer, coming up in this new spring season, before touring, ask, is there anything I need to sign before I see this house? And if the agent, again, looks at you a little funny, like, what do you mean? Sign what? Right? That's a great interview tactic. You know, I would, if an agent can't answer that question right off the bat, I would really take heart on whether or not I was going to hire them to actually represent me in the sale of, or the purchase of that property. So if you want to learn more about this, you can always like the video. You can send me a quick note. But this is the best summation that I can that I've seen, that I've read so far on what the changes are with TRELA and showing only requests and buyer representation. And if you like these kind of videos, hit like, subscribe, and you'll see more come in the coming year on more details of what's happening on Texas law.